Recording in progress.
Good morning, welcome. We'll give it another minute or so and then begin.
Hey folks, can we have permission to record straight onto this?
Yes, that is fine. Thanks for asking.
Yeah, just make sure you approve the requests that come in.
Will do. Allie will
Thanks.
take care of that.
Good morning. I'm Alejandro Isturiz, Telemundo 51. I need to record in too, please.
Yes.
Thank you.
Okay, it is 10:02. I think we'll go ahead and get started. Welcome, everybody. I'm Eve Samples, Executive Director at Friends of the Everglades. Thank you so much for joining us at this virtual press conference in response to a really significant win in court yesterday when Judge Williams issued a preliminary injunction in our case to halt harmful activity at the Everglades Detention Center in the heart of Big Cypress National Preserve. You're going to hear from members of our legal team today, and I just want to kick it off by saying a few words. What happened yesterday and what we saw from the court is not only a victory for the Everglades, it is a victory for the rule of law and for holding government accountable. It is important to remember that environmental laws in our country stand on equal footing with other laws, and they are being tested in ways that we haven't seen in more than a half century. This win shows that we can uphold them when we work together and we demand it and present compelling evidence, which we did in court. So just to orient you to the site in question, the Everglades Detention Center site is on the old Dade Collier Training and Transition Airport facility. It's completely surrounded by Big Cypress National Preserve, the country's first national preserve. It's about 6 miles from Everglades National Park. National parks in our country have been called America's best idea, and we have been calling this detention center America's worst idea. And that's for a number of reasons, including threats to endangered species, threats to Everglades wetlands, and a complete disregard for the National Environmental Policy Act, a bedrock environmental law that we filed our lawsuit under on June 27th. We also took additional notice of legal action under the Endangered Species Act and other laws that we'll talk about. So a significant win this morning. The order from the judge means no new detainees can be brought on site as we sit today, no new construction. Within 60 days, the site has to wind down in an orderly fashion. So this is big, but it is not a final win. We already know there will be an appeal. So I'm going to stop there, and I want to introduce the rest of our group today. I have with us Elise Bennett from the Center for Biological Diversity, Paul Schwepp, who is our lead counsel with Coffee Burlington. He's joined by Scott Hyacin, who is his partner there. Tanya Galoni from Earth Justice, our co-counsel, Curtis Osceola of the Miccosukee Tribe, who stood with us as co-plaintiffs in this lawsuit, along with the center, and Representative Ana Escamani, who testified as a witness in the case. And I also just want to acknowledge a few other folks in the room. Jessica Namath has been documenting harm coming and going from the site for weeks on end. We're happy to have her here in the audience. And Amber Crooks also played a really vital role in testifying as a witness. So with that, I'm going to hand it over to Elise to say a few words about what this means.
Thank you, Eve. I'm Elise Bennett. I'm the Florida director and an attorney at the Center for Biological Diversity, and we are honored to celebrate this victory with our co-plaintiffs, Friends of the Everglades and the Miccosukee. Goes hand in hand with protecting people. Our well-being is intertwined, and that's why Congress created the National Environmental Policy Act and other landmark environmental laws to safeguard the health and welfare of people by requiring the government to carefully and publicly consider the impacts of its actions on our land, water, air, and biodiversity. The need for these safeguards is even stronger today than it was when President Nixon signed NEPA into law more than 50 years. Detailed in Judge Williams' 82-page order that DHS and ICE ignored NEPA's modest mandate, leaving the public and nearby Miccosukee tribe in the dark and irreparably harming delicate wetlands and endangered panthers and bats. These statements should be obvious, but the Everglades need less pavement choking her native soils, not more. Less stadium-style lighting blocking out the starlight, not more. The weight of the law and public opinion is steadily phasing out this illegal, destructive detention camp, and we plan to work tirelessly to keep it that way.
Thank you so much, Elise. And I'll just add that we will have some time for Q&A after we hear from all of our speakers. I'll pass it now to Paul Schwepp of Coffee Burlington.
Yeah, I just wanted to take a minute to congratulate the fantastic team of lawyers that I was privileged to work with on this case, including my partner, Scott Hyacin, Elise and Jason from the Center for Biological Diversity, Tanya Galoni and Dominique Burkhart from Earth Justice, just an amazing, talented group. You know, they say success has many fathers and failures an orphan. In this case, success had many mothers. And that starts with kind of our quarterback, Eve Samples, from Friends of the Everglades. And it's always an honor to be aligned with the Miccosukee tribe of Indians. And we're just so grateful for their participation. The judge's order is really an amazing piece of legal handiwork in just a remarkably thorough, comprehensive, exhaustive order that she churned out in a remarkably short period of time. She dealt with every argument by every party and in a methodical way rejected the assertions that were being made by the defendants. She concluded this was a federal facility, that the federal government could not disclaim it, that there was a complete and total failure to comply with the requirements of the National Environmental Policy Act. And then she reached a very measured and balanced resolution to order a structured, orderly phase out of operations that would not cause any disruption there, but still preserve what's important to all of us, the Everglades, and preserve the requirement that folks comply with environmental law before they undertake an endeavor like this. So we're grateful for her opinion. There's already been a notice of appeal filed. We are sure that the defendants will seek a stay of the judge's order, and we're prepared to meet that motion to stay with the same energy, vigor, with the law and the facts that we brought to seeking the injunction in the first place.
Thank you so much, Paul. I'll pass it now to Tanya. Tanya, you're muted.
Can you hear me now? Thanks. Tanya Galoni. I am the managing attorney for the Florida Regional Office of Earth Justice. And Earth Justice has fought for decades alongside our clients and partners like Friends of the Everglades and Center for Biological Diversity to protect the Everglades. And as you know, as residents and as taxpayers, we have all contributed to protecting this incredible ecosystem. We have spent billions of dollars to restore the Everglades that has not only ecological significance, but also significance for water supply and water quality, and affecting especially South Florida, but also of great national importance. We are standing up in this case for NEPA, as Elise said, which is a basic statute that requires agencies to look before they leap, to study the impacts of a proposal before they take action. And that statute, Congress passed it decades ago, precisely to avoid a knuckleheaded move like what we've seen with the creation of this detention center in the middle of the Everglades. The statute requires consideration of environmental impacts to communities, and an opportunity for public input, none of which was provided here. It's a bedrock environmental law that we have, and for good reason, because now we see what happens when there is no NEPA and when there is no compliance with NEPA. And we're just grateful that the judge took the time to consider all of the evidence, and as Paul said, really methodically consider the facts and the arguments to find that this couldn't continue.
Thank you, Tanya. We'll pass it now to Curtis Osceola.
Thanks, Eve. Curtis Osceola, I'm the Senior Policy Advisor to Chairman Cypress at the Miccosukee Tribe of Indians of Florida. First, want to congratulate the other plaintiffs in this case for the decision rendered yesterday by Judge Williams. I think we're all very, very excited and happy for her comprehensive order, basically requiring that the National Environmental Policy Act be complied with, and issuing a mandate to the state saying, you got to wind this down and you got to do it now over the next 60 days. So we're excited to see that. She recognized the tribe's interests and rights to access our ancestral lands and our cultural sites. Though we are happy with the result in the order granting the preliminary injunction, we are still concerned because the psychic harm, the mental trauma that our children and our young adults are going to have to live with because of the imposition of this facility on their homelands will be felt for generations. And really disappointed that we had to go this route. We were, I think, at the fore, with the administration trying to get this thing to wind down, but we were not heard, and the tribe's voice was not listened to in a matter, in many manners of speaking. We weren't consulted with, and today's order, or I should say last night's order, really vindicates the tribe's rights, and we will continue to defend our sovereignty and our homelands. Chairman Cypress wanted me to add that, when it comes to our homelands, there is no compromise. And so we will continue to fight. This will be appealed. We imagine we are prepared to go all the way to the Supreme Court. This is not the first time the tribe has been in a fight like this. It probably won't be the last, but we are prepared to fight and we are prepared to win. So thank you.
Thank you, Curtis. Friends of the Everglades is honored to stand with the Miccosukee tribe as we did 20 years ago in successful Clean Water Act litigation, and very proud to stand with you in this victory today. Representative Escamani, would you like to add some words?
Thank you so much for having me part of this press conference today. And it's just quite humbling to be among this pristine group of advocates and attorneys that have led the fight to ensure that environmental law is followed and practiced here in the Sunshine State. Those who don't know me, my name is Representative Dr. Ana V. Escamani. I serve District 42 in the Florida State Legislature. But as it was mentioned, I was a witness alongside others in this case, providing evidence as someone who's actually set foot on the facility while it is activated. And I shared my experiences of the construction materials, of the environmental impact that took shape in new asphalt, that took shape in the Sunbelt light infrastructure, that took shape in just the human density of what the state was already doing, and of course what they were planning to do, in the sense of the impact of having thousands of people be placed in detention camp in the middle of the Everglades. And so yesterday's injunction is a resounding victory for Florida's environment and for justice. The Everglades, as we all know, is one of the most unique and fragile ecosystems in the world. And the entire state of Florida is reliant on a healthy Everglades. The idea of carving it out for a sprawling detention camp was both reckless and cruel. And of course, this ruling will help protect our wetlands, our wildlife, our water supply, while also affirming our commitment to Florida's environment and its people. We deserve solutions as a state that protect people and the planet, not projects that devastate both. And we are all committed to continuing this fight into the future. Thanks again for having me.
Thank you, Representative Escamani. Before we open it up to questions, I just want to add that Friends of the Everglades organization was founded by Marjorie Stoneman Douglas in 1969 to protect this very location from harmful development. Back then, it's what would have been the world's largest airport, the Everglades Jetport. That was halted because people of all political stripes in Florida and beyond rose up. An environmental study was done, and the damaging development was halted. The history of this very site shows that when government studies its actions, we can choose a better course. So history is repeating itself. We have won now this preliminary win in court. The court has sided with us and agreed that the government has to comply with federal law and conduct an environmental impact study, halt activities so that can be done. And the hope certainly is that we can choose a better course of action. It is impossible to imagine that a massive, expensive, harmful immigrant detention center in the middle of the Everglades is the best course of action. As I said earlier, this sure looks like America's worst idea. So with that, I'd like to open it up to questions from the group. If you would just raise your hand using the raise hand tool, we will call on you and get to as many of you as possible. So we'll start with Joshua.
Hi, thank you. Can you hear me okay?
Yes.
Hi, two quick questions. First, the judge's order said that she was denying the motion for preliminary injunction in part. Can you explain what that denial was? And second, since this is a preliminary injunction, will this case go forward? Will it move to a jury trial? What are the next steps?
Paul, would you like to take a first crack at that?
Yeah, thank you for the question. We had there's a count in our complaint that referred to the state's lack of authority to do this, and she, in a footnote, declined to rule in our favor on that count. That's why it was denied in part. Yes, the case will move forward. We have additional claims that we've already provided notice that we will be asserting. So within the trial court, it will move forward, not to a jury trial, but to a bench trial. And then, as has already been noted, there's been a notice of appeal filed by the defendants in the 11th Circuit Court of Appeal. And we anticipate that the defendants will be seeking a stay of this preliminary injunction in the Court of Appeal. So that'll be the next immediate step.
And Paul, just to clarify, when you say the state's lack of authority to do this, to build the center, not to move forward without compliance with NEPA, right?
Yeah.
Thank you.
Okay, next question.
Hi there, it's Christina Vasquez from Local 10 News. I don't know how to raise my hand on the mobile version of this, but can I ask a quick question?
Absolutely, please.
Great. I'm just unpacking one more time for the legal next step. So in federal court, there's no automatic stay for the government, correct? And so it would be that they would need to file that motion for a stay, and then that would be then that motion on its own litigated. Do I have that right?
Tanya, Paul, would one of you like to answer that?
Tanya?
Oh, you're muted again.
Apologies. Yes, they would have to file the motion that would be litigated, and then the court would ultimately make a decision on it.
Thank you.
I see some hands raised in the chat, so I'll look here. Patricia Mazzei, go ahead.
Hi, good morning. Thank you. Did she actually spell out, the judge, in the ruling, government do perform a NEPA analysis and come back and you can rebuild it? Or is that sort of not said? That wasn't clear to me. Like, can't the government say, we're going to do a NEPA analysis and then just build?
I'll defer.
I can comment. I think I can comment on that. So I think the judge was clear that because no NEPA was performed here at all, I mean, at a bare minimum, even an environmental assessment wasn't done. And so basically what she's saying is that because there was no compliance, that any facilities that have an impact on the environment have to be removed within 60 days. So, if they went through the environmental impact process, there would be a public comment period. There would be, input from the outside, and then the government would have to respond to that. So I think the purpose of this action was to avoid all of that and to make a statement on immigration. And instead, what they did was they made a bold statement about the how we are willing to sacrifice the government for politics. And I think that was something that really stood out to the tribe. And it was something that we had to fight. So
can I add one thing to that? Curtis is right. NEPA just creates a procedural obligation on the government to study alternatives to proposed action and the impacts of the proposed action. So yes, it's correct to say it doesn't dictate a particular result, it just is a procedural requirement. However, any rational NEPA analysis of the alternatives to this site and the impacts that this site poses would conclude it makes no sense to build a 5,000 person detention center in the heart of the Everglades. There are other alternatives, as the governor has already recognized.
Thank you, Paul. I'm going to go through the hands I've seen in the chat. We'll go next to Evan Axelbank.
Hey, folks, how you guys doing? I'm not sure who wants to take this, but I just want to ask, the reaction here to, the governor's, claim and insistence that this is something that they expected and that this is a ruling that is going to be brushed off legally and that ultimately he'll emerge victorious. We've seen that happen a number of times on lawsuits. He said the fix was in this case. Just what's your reaction to that?
Paul?
Yeah, no one's declaring victory, right? The key word in the preliminary injunction is preliminary. So we understand that we have a lot of work ahead of us to defend this win in the 11th Circuit Court of Appeal, and then to turn a preliminary injunction into a permanent injunction in the trial court. But we really believe we have the facts and the law on our side, and all you have to do is read the thorough and exhaustive opinion of the trial court judge to realize she came to the right result. And we believe a court of appeal will affirm her decision.
I'm wondering if someone just with a better, more clean camera shot could take that one. No offense. I just
need it as well as Paul.
Yeah, no offense. It's just the camera shot's not great.
Right.
Yeah, Paul, you got a pretty bad glare.
Tanya, Scott, Dominique, or Elise, sorry, were you trying to jump in?
Anna?
Yeah, I don't know if my camera shot's that much better, but I think we can say this is an important victory, but it is a first step. We will have to defend it in the Court of Appeals. But we're confident that the facts and the law are on our side, and that was detailed in the judge's 82-page opinion, painstakingly going through all of the facts and the proof. And what the defendants, the state and the federal defendants, were not able to show was as telling as what we were able to show.
Thank you. Elise, were you trying to chime in?
I was just going to say that it's worth adding that we're going to have an opportunity to present more evidence and make more arguments. But one of the things we had to show to obtain this preliminary relief was to show a likelihood that we would succeed on the merits of our case. So this gives us a lot of faith and hope as we continue forward in this fight.
Thank you. Okay, Jamie Ostroff.
Good morning, and thank you for doing this and bringing everybody together for this. I have two questions this morning. First, what can or will be done to ensure that the breakdown of the site and its infrastructure is handled in a way that's environmentally responsible? Ostensibly, when you're tearing something down, it's going to create waste. And my second question is, we're kind of in a unique situation here with the tribal lands, the national preserve, and the proximity to a national park. But there are other pop-up immigration detention centers coming up all over the country, including another one in North Florida. Can the litigation in this case...
I can take the second part of that question. I already kind of lost the thread of the first.
Go ahead, Tanya.
Well, I think as to the second part, I think for other detention centers, that's going to be a kind of a case-by-case basis. But I think what this decision shows is that states can't just claim that they're doing this on their own. This is clearly a state and federal partnership, which means that federal law applies and federal law has to be complied with.
I'm reminded of a question that the judge kept asking, and it was, why in the Everglades? Can anyone tell me why? And no one could answer that clearly from the government. And it was pretty obvious, I think, to all of us in the room, all the plaintiffs at least, that there was no explanation other than this was a publicity stunt. So we're happy that the tribe's rights were respected. We had our scientists that testified and showed that there's real human harm that's happening right now, and that will continue to be built upon, unfortunately.
And I'll just say with regard to the first question that you asked, this action that we brought has demonstrated that we are vigilant, and people like Jessica Namath are out there regularly documenting what's coming in and out of the site. And if this site is not brought down in a environmentally responsible manner, responsible in totality, really, then we will be alerting and moving through the proper channels. All right, we're going to move on in the interest of time here. I see a hand from Kennedy Mason. Okay, if we don't have Kennedy, we'll move on to Eileen Kelly. Not hearing Eileen either.
Oh, yes, here I am. Okay, sorry.
Okay, that's okay.
Yes, my question was also asked, but it was about how you were going to monitor. Is there any, are you going to go back to the judge and ask for permission to go onto the site to assure that it is that beyond just from the street, and not to say that Jessica and everyone hasn't been out there around the clock, but in terms of monitoring for environmental impacts and to make sure that they are doing what they are ordered to do, provided that an appeals court doesn't stay the order, excuse me.
I think we're taking it one step at a time as we digest this really impactful ruling. It's a very good question, and accountability is critically important. Following the rule of law, the judge's order is critically important to us. So I think we'll need to follow up with you on that front.
Yeah.
But
And one more. If the government was to have followed the rules and gone through NEPA, is it safe to say that that's probably a year-long process in terms of the environmental impact studies, giving people time? Is it roughly a year, or am I way off with that?
It can be more than a year. One of the things that we brought forward in court was this extensive NEPA process that allows for many opportunities for public input, scientific analysis, alternatives considered. We at Friends of the Everglades have participated in multi-year NEPA processes like the Lake Okeechobee System Operating Manual. So it depends is the answer.
Okay, great.
I think I would also flag that the more likely environmental impacts a project is going to have, the more time it will take to review those impacts. So that plays a big part also in consideration of alternatives. You try to avoid environmental impacts for that reason.
Okay, thank you so much.
Yes,
It's been the tribe's experience that most environmental impact statements or studies take 1 to 2 years in the Big Cypress.
Thank you, Curtis. Kennedy asks in the chat, how quickly do you expect this to move through to an appeal, or how quickly could it get to the U.S. Supreme Court?
There's some guesswork involved there. I expect the defendants to rapidly seek to stay this preliminary injunction, by which I mean it wouldn't shock me to see a motion filed today, which would in the first instance be resolved by the trial court judge. Then they would need to move to the Court of Appeal. We would be provided an opportunity to respond. So it'll play out over some period of time. If the Court of Appeal denies a motion to stay, which is what we hope will occur, then they can seek relief from the U.S. Supreme Court. If you want to understand that glide path, all you need to do is look at what occurred in Judge Williams' decision in the Utmeyer case, which went through a similar process.
Thanks, Paul. We'll go back to Forrest, then we'll go to Juliet and Christina, and we have about 5 more minutes probably.
Appreciate it. I'll be as brief as I can. I actually have a question for Representative Escamani. Given that we have the Baker facility that's apparently going to be starting up here in the next 2 weeks, I'm wondering if they have similar concerns about Alligator Alcatraz versus this deportation depot, which is what the governor's office is calling it, and whether or not they plan on doing any kind of site visits like they did down in Alcatraz.
For sure. I appreciate the question. I put this in the chat, but I think it's worth noting that based on conversations we're having with individuals who are detained right now in the Everglades, that the state of Florida has been depopulating this facility. Based on Congressman Maxwell Frost's visit of the location yesterday, he was told that there's about 340 detainees currently at the Everglades camp, which is substantially lower than when myself and other lawmakers made that scheduled visit on July 12th. And so my assumption is that the state of Florida expected a loss because they did not do their due diligence in any type of environmental study in building this facility in the middle of the Everglades. And so they were intentionally transferring individuals to other facilities, and now they're pushing for Baker CI to be established as a detention facility as quickly as possible because they know the Everglades is not going to be suitable for this, and that opening up the Everglades was a political decision, not a policy one. With that said, environmental policy as it pertains to Baker, since it's a pre-established facility, I doubt it's going to have the same type of evidence as we've seen with the Everglades. With that said, concerns of due process will remain for those of us who operate in the legislature, and we absolutely will be visiting Baker CI, especially since it's a former state correctional institution. I would assume that as state representatives and senators, we should have the ability to visit state facilities unfettered, without delay, without warning, and we'll be practicing that same statutory authority at Baker.
Okay, we'll go to Juliet now.
Hi, good morning. Thank you. Back a few weeks ago, your side had said that you had been running tests as to the impacts that had been kind of already in place over the last 6 weeks that this facility had been open. Do you have any of those results yet to share, kind of what maybe has been actually impacted in the Everglades since the facility was put up? And do you have any plans to continue any testing once the facility starts to wind it down to see what the impact was while it was operational?
I am not sure about the testing you're referring to, but I can tell you that we have been quantifying through aerial imagery and the work of wetland and soil expert Dr. Chris McVoy, the expansive addition of asphalt at the site. And we also heard from an expert witness on stormwater during our 4 days of hearings, who testified about the inadequate stormwater system that has been installed or not installed in conjunction with that new asphalt. We've also documented light pollution that can be seen from upwards of 15 miles away from the site. Once one of the most incredible dark sky areas in the southeastern United States. So in terms of quantifying impacts through data, frankly, that's what the government was supposed to do and didn't do, and why we brought this lawsuit. And we have, I think, done yeoman's work quantifying tangible impacts, and that's why part of why we saw a positive outcome from the judge. Does anyone want to add to that? Okay. All right, we have one more from Christina, and then we'll have some closing words.
So you have a lot of work done to turn a preliminary into a permanent injunction in court. Can you just unpack what those steps would entail for you exactly? I don't know if that's something that is, if the appellate court then affirms this decision, if that's the moment, or is there going to be
okay. We're losing your audio a bit, but I see your question in the chat. Let me just read it for the group. What are the legal next steps to move from preliminary injunction to permanent? Does that happen if the ruling is affirmed on appeal, or is that a separate issue that plays out at a new hearing? Have plaintiffs filed a motion for permanent injunction? Paul, would you like to jump in on that?
Yeah, so the process is the case will move forward in the normal course. We'll be entitled to conduct some discovery in support of our claims, as will the defendants. The judge will set a scheduling order. We suspect there will be cross motions for a summary determination of the legal and factual issues in the case, and that she will rule, and we hope consistently with the preliminary injunction, on a permanent injunction. But that will play out over time, and that's a separate process from the appeal process on the preliminary injunction.
Thanks, Paul. Okay, so we're going to wrap up here. If you have additional questions, feel free to follow up with us through the information in the press release. I'll just open it to our group to see if anyone has any final words before I wrap it up here.
I just wanted to add on the tail end, especially with a lot of the questions about next steps, that I think it's been clear to the public that there are many legal violations associated with this facility, and beyond violations of the National Environmental Policy Act. We also intend to vindicate other environmental laws, including violations we've noticed under the Endangered Species Act, Clean Water Act, and laws that govern our public lands like Big Cypress National Preserve. So, it's worth pointing out that this so-called administration of law and order has been breaking the law every step of the way here, and we intend to hold them accountable to these environmental laws.
Thank you, Elise, and thanks to all of you for joining. We'll keep you posted as our legal action evolves. But for today, we are celebrating, cautiously optimistic and celebrating this preliminary win. We know that we will have to fight hard on appeal, and we believe we have a very compelling case. So thank you. We look forward to keeping in touch.